righty, welcome back everyone to another great episode of The Human Role. So today we are going to get into what I say MESTA, the Michigan Earned Sick Time Act, and I have a really great colleague of mine and business attorney, James Reid. So James helps many employers with their, business laws and helping them navigate complex, workplace laws in our industry. He also is a speaker and a thought leader on the HR side, doing many speeches through SHRM, definitely the American Payroll Association, where we all met. And so James resides in Michigan and has a lot of great insight on the new laws that have been just coming out with their sick time that have been very confusing at times to a lot of our HR partners. So before we step into that, I'd love for James just to give, a little more insight on his background. And this one is a very special edition episode, being that Michigan sick law has another update coming soon. So James is going to give us some great insight there. But James, thank you so much for joining today. Very excited to have you. And for anyone in my network who isn't familiar with you, I'd love for you just to take a few minutes and give them some more details on your background.
Sure. I'm James McGregory the fourth, and I joke my son is the fifth, so pressure's off. I've been an attorney for nearly 20 years, and I volunteer my time servicing various organizations like the Society of Human Resource Management. I'm the past director of that for Michigan. I also volunteer for several chapters, and I also speak on various HR, payroll, and other hot employment topics. So I try to keep up to date and tell stories to keep everything fun and exciting. So I appreciate you taking one of my lines, calling it MESTA, because that does make it fun to joke and see what a mess this is, as many other states are also passing similar sick leave laws.
Yes, very true. First time I heard MESTA put together was on James' webinar some months back when we were kicking off. I think the first launch was in Q2, beginning of Q2 of some sort. So for James, let's give some people some background. So for people who may not be in Michigan, or employers who didn't have any employees in the state of Michigan, or even some that have but just need a refresher, how about you just give us some details on the backstory of how this even came about?
It's a very somewhat entertaining story. So back in 2018, the Democrats were about to have the people vote, should minimum wage be $15 an hour, and should employees have at least 72 hours of paid time off. And obviously, a majority of people in Michigan would say yes to both, because they would like more money and more paid time off. So what the Republicans did is said, whoa, let's not make this to the vote of the people. Let's work through legislature and come up with something that's fair and reasonable, so we can just accept what you're proposing and then tweak it. So after they accepted it, they then amended it and said, instead of it applying to any size company, let's have it only apply to 50 and over. Instead of it applying to $15 an hour, let's have it be $15 an hour by the year 2030. So all of this backtracking and tweaks was the law for the last 5 years. And then what happened is it went to the Supreme Court, and the court said what the legislature did, this whole adopt, wink, wink, knowing you're going to amend it in the same cycle, is not valid. So as a result, the old law initially proposed by the Democrats is the law in effect. And essentially, that's why we call it MESTA, because when Democrats propose a bill that isn't heavily negotiated, they're missing a lot of the concepts and application of the concepts. And so a lot of the initial bill doesn't make logical sense. So the court said you have until February 15th of 2025, or sometime in February, maybe it's February 21st. And essentially on that date, the legislature amended the laws slightly and made it a little bit more pro-employer. So the Paid Medical Leave Act was replaced with MESTA, the Michigan Earned Sick Time Act. And now you get 1 hour accrued for every 30 hours worked up to 72 hours. And if you are at 10 or less employees, you get 1 hour accrued for every 30 hours worked, up to 40 hours. And why this is a timely update is that on October 1st of this year is when all small businesses, 10 employees and under, have to roll out their MESTA policy. So that includes, how are they going to accrue the time? Are they going to front load 40 hours? Are they going to accrue it 1 hour per 30 worked? And you also have to have a policy in your handbook and a poster in your break room that discloses an employee's rights.
That's interesting because I almost remember, and correct me if I'm wrong, when this was first launched, there was no cap on rollover, right? Is that still the case? I think what you're saying is they reach up to 40 or 72 hours, but that's what really was throwing us off as I was helping a company earlier this year. There was so much confusion around everything. And of course, we have to go to executives to get approval, and they just did not understand.
The scariest part of the law was this unlimited 1 hour for every 30 worked. And a lot of people, claim to be working 100 hours a week and to carry over hundreds of hours that then if they double up year over year, having those on the books is very challenging. And what happens when someone leaves? Does an employee feel like they're entitled to that money, even though under the law, it's forfeited upon separation? The other scariest part that is less scary now, as there was a private cause of action. So if an employee was ever fired for missing work or taking any leave, they were essentially presumed guilty of retaliation. And there was a private cause of action to sue employers. The most recent amendments got rid of the private cause of action. So instead, you can still bring a claim to the Michigan Wage and Hour Division, but not sue for a violation of that law.
Well, lots of good changes. And then just to reiterate, the deadline for October 1st is focused around the small businesses, right? So with 10 or under employees, large businesses should essentially have already had this launched earlier this year, but the new deadline focuses around small businesses, which at times this can be really tough, right? For a small business as they're going on slimmer teams and, budgets are a lot tighter, but just wanted to make sure everyone, heard that and understood that as well.
That is absolutely correct. But for some reason, you don't have your policies in place and you're more than 10 employees. It's still better to go ahead and correct that now than wait to get in trouble.
Yes, of course, because the states are waiting, I feel like, for anyone to slip up along these lines. But okay, so that's great stuff. That's a big update. We definitely wanted to bring you all. But I love, James, to also pick your brain around what other insight or advice would you have, not only for employers, but maybe even for employees? And then, not to mention, since you are in the state of Michigan, do you have any insight of what potentially could be coming for the future? I mean, do we think this is kind of it and set in stone, or are there still, are there people still filing, claims or lawsuits against Michigan to where we just need to keep an ear and eye out for any future changes?
So I'm not anticipating any changes to paid sick leave anytime soon in Michigan. But where I'm seeing some bills being proposed are non-compete agreements and restrictive covenants. So there was this FTC ban proposal where if you made under $150,000, non-competes should be unenforceable. Michigan is in the works of proposing a bill where if you make under 75,000, non-competes should be unenforceable. And some judges are being more pro-employee when reviewing restrictive covenants. So I am encouraging my clients to be a little more precise in what they're trying to protect. And a lot of the time, you don't even need a non-competition agreement. You could just have a strong non-solicitation of customers or employee agreement, which is way more enforceable and still allow that employee to earn a livelihood and find another job that isn't directly soliciting business. So restrictive covenant law is hot. I would also say wage and hour laws are still hot with people working remotely. What is time worked? Are they working while they're sleeping at night, thinking about emails in bed, having their phone on their person? You want to make sure you're exempt employees where you don't have to track time truly meet one of the exempt tests so that you don't have to worry about wage and hour nightmares. And then I would say 3, the most innovative policy all companies need is artificial intelligence. I feel like a lot of people don't realize by recording your virtual meetings, you're probably losing attorney-client privilege because there's a third party that has access to your information. A majority of your employees are using AI, whether you know it or not. So you probably want policies. Are they allowed to share your company's confidential data or customer data with these AI tools? Which AI tools are approved or not approved? And have certain requirements in how to use technology, because technology is always ahead of the law.
Very true. I feel like we're going to be trying to catch up with AI for quite some time now. Every minute of every hour, it's like changing and evolving, and there's something new to come. So all great things, you guys. And actually, that's a really good point, just to make sure when you're recording calls, especially talking to clients, that you're being really, really cautious with that as well. That's one thing that I don't think I really thought about. I was always being cautious of what was loaded into AI and what you feed to it. But this is another factor that we need to take into consideration. So all great insight. I'll read it.
Yeah, and that reminds me of something equally important, which is a record retention policy. Because as you have more recorded conversations and emails and meetings, you don't want to go back 20 years if there's ever a lawsuit and have to give every recording you ever had. So you may want to develop a policy of how often you delete emails that aren't saved to a certain file number. For example, at our firm, we delete emails every 90 days that aren't saved to a client file.
I mean, hey, if there was ever a time to make sure we got that together, but also when do we have time to do those things? So yes, but those are all really great insights. I think building out folders, putting in recordings, naming them properly, dating them is all necessary. So I would say take it from an attorney if you're going to take it from anyone. I'm sure he has dealt with many of the lawsuits, you guys. So he's not saying this just for fun. So let's make sure we pay attention and take note and find some time to bucket out. And what was that again? A retention policy?
Record retention policy.
Record retention policy. There we go. Alrighty, James. Well, thank you so very much. This was very, very insightful, you guys. I caught up with James luckily last week, and we were like, okay, all these new laws. I was not aware of the October 1st deadline coming out. So he definitely encouraged for us to get this out there to you all. So please make sure if you have any questions, ping him, send him a note. And if you need any support on anything when it comes to Michigan, him and I both can help you all. Myself with the system stuff, him on his side with the law. So thank you, James, very much for having you today. Really appreciate it.
Always a pleasure. And have a great day.
Yes. All righty. I will see you guys in another few weeks for another great episode. Bye.